granted. And he was asked by Mr. Namanje that if bail was granted, would he have a problem if they report to the ACC? I'm paraphrasing, I don't know if it's exactly that, but I remember that very well. And he said he will not have a problem if he reports to the ACC. But later he was asked, I think it was in cross-examination by Mr. Namcor or Mr. Casper, to which he says, no, I retract that. In fact, my purpose of being here is to oppose bail. That is just one contradiction. I think I've stated it in my head that I can remember of with regard to the testimony of the investigating officer. That is just one. If I cannot remember of anything else, but if we, because it stated that, well, he did not consider the contradictions of the investigating officer, but placed much emphasis on the contradiction of the first and the second appellant, or the other appellants. I can just mention a few with regard to the first appellant, because during evidence in chief, for instance, he was asked whether the assets belong to, by the assets I'm referring to the fuel station, belong to Namcor. He said Namcor build the resources with their own money, so they belong to them. But then when I asked him in cross-examination, I can refer to the record, which I've also outlined in my head, the contradictions thereof. Yes, it appears on page 6 of my head. For instance, the issue of whose service station those were. But as he had said, they belong to Namcor in his evidence in chief. When he was cross-examined, and that appears on page 502 of the record, he was asked whose service stations were those. His response, the record speaks for itself, was that the service stations belong to the Ministry of Defense. But then when he's asked later, he says, when I told him, when I asked him that I'm not concerned about the ones that were decommissioned, he says we sold title and the assets that we put in the ministry were well those assets. So he does not, one moment he says, well, the assets belong to the Ministry of Defense. One moment he says, well, they are assets of Namcor. And again, on the other aspect, with regard to the fourth appellant, when he was asked whether he got board approval to sell the assets above 25 million as per the schedule of authority, his response in evidence in chief was that he did not need that. But in cross-examination, when I confronted him with the schedule of authority he was referring to say, well, it says so. He says there was a word that he uses. An oversight, yes. He says there was an oversight on his part. So that is a contradiction. And as much as because he accepted that, well, there was no board approval. But when I asked him, why did you go ahead and do that? He says it was an oversight. Well, he agrees, but then he gives a contradictory answer and says it was an oversight on his part. Another aspect, contradiction, was that one that relates to the business development budget. With regard to the third action, where I asked him that, do you have proof? Do you have proof that was that the budget to acquire the assets was in the business development budget? And I asked him whether he has proof thereof, and that appears on page 1130 of the record. So that is a contradiction also. And
can I stop you there?
Yes.
And when I'm stopping you, I'm not interfering for you to list your contradictions. You can even list 100 of the contradictions. The question is, how do those contradictions go to the heart of the bill rather than the merits of the trial?
My lady, the view of the question by the court is that it is not us who raised that issue, because we have said from the onset that we are dealing with the issue of bail. So the issue of contradiction is raised by the appellants. My argument will be they do not really, in as much as they are there, they do not go to the heart of the fact that whether candidates are.
So they don't go to the heart of the bail, but rather to the merits.
To the merits, yes.
Which means that they are immaterial, or they're material to the bail.
Well, they are material, but of less probative value, because I'm saying, in as much as they contradicted themselves with regard to that aspect, or to various aspects, can it be said that they go to the core of them being candidates of bail or not? We will say, well, it's issues to look at, but they are of less probative value when an inquiry of bail is being held.
Thank you.
Thank you,
You're off.
Mr. Lim.
You're off the hook.
After 3 hours of argument from my colleague.
Yes, but Mr. Namanji, I must come up for your colleague here. A lot of them was addressing the court's questions.
Yeah, no. I'm not criticizing. I'm just an observation. And no wonder he was entitled to sweat. Like we saw on TV. Okay. My lady, it is with disappointment that I will be replying, because with greatest respect, there is a duty, particularly by senior counsel, when you make arguments on a serious matter such as liberty, given our history, you better make sure that you are not maybe innocently misleading court. My colleague was referring the court to section 28 and 23 of the Anti-Corruption Act. And Justice Rako, you were correct, and of course Justice Christian to probe him and say that Hairul, in fact, Justice Rako in Hairul, it was not even general. Justice Damaset was exactly dealing with those sections, because the case is Hairul versus Anti-Corruption Commission. So my colleague, these arguments he was making, trying to, as if it's only now the court is interpreting that section, belong in a legal museum, in a law museum, my ladies. We have already argued those things in 2012 when we argued Hairul, and the court said, unfortunately, in this constitutional era, it's not open for an ACC or police officer of the 4 available modes of bringing a person to court to simply go directly to the most invasive one, that is arrest. Justice Damasep said, because of the right to liberty, arrest is a last resort. That's what the judgment is saying. But after that judgment, and I thought my colleague is aware of this judgment, and in fact we produced their own record, we produced them to the magistrate, some of them, and I named them 3. The most important one my lady, is the judgment of General Nopoju Amyera, who I'm even embarrassed publicly to state that somebody who was the army commander of Namibia and a freedom fighter as Justice Shiminche said in the judgment that is shocking the way he was arrested with only, and those charges had fallen. Justice Shiminche said, you've got to first assess whether arrest on that particular case is necessary. That is Minister of Security and Safety versus Hamyera. There's another judgment by Justice Waitere. It's called, again, is Minister of Safety versus Simon Tuhafeni. And I will ask my juniors to make those copies. Again, Justice Waitere stated that you can't, because of history, you got to make an assessment. And if you are not aware of your discretion, that you have a discretion, you are not obliged to arrest. You can use someone. Then actually failure to apply a discretion is unlawful, my ladies. Again, and at another level, failure to apply it properly and lawfully is a misdirection. If you don't apply it at all, thinking that, remember our people were inspired by the media when somebody allegedly committed an offense. You find even land people apparently say, why was he or she not arrested? Nobody speaks about someone. So the court is teaching the public and everybody, including the prosecutors, that, hey, first make an assessment. So their judgment, your ladyship, you are not going to be the first one to interpret that section. Has already been interpreted in Hyrule. I'm done with that issue of necessity. And my lady, it's not a big thing. It's just logic, not law. If on the facts you find through cross-examination to the investigating officer that there was no justifiable necessity to arrest, it follows by necessity that being remanded in custody is also unnecessary. There is no necessity to remand in custody if primarily there was no necessity to arrest. In other words, if you don't have fear that a person will run away, will not attend court, will not interfere, and there will not otherwise any danger to the administration of justice. I move from that, and the last one on that aspect is...
Before you proceed, Mr. Namandi.
May I proceed?
We want to just manage time.
Yes, I will.
So you have 15 minutes.
Yes, I will.
Each one of you.
Yes. But it's from here now that I know now.
And don't steal your colleagues' minutes.
And now that I know, my lady, but I mean, it's a serious matters that were raised, my lady. And,
if need be, we can determine.
I was troubled.
Cut off is 15 minutes.
Yeah. I was troubled, my lady, by the manner in which my colleague dealt with the questions from court on liberty and, say, for instance, interest of kids when you take a parent away and the Namibian Constitution, my lady. Our preamble, read together with the judgment of S versus Akeso, my lady, says that one of the things, a commitment made at independence on the 9th of February when our Constitution was adopted, is an obligation by all institutions and every individual that we must cherish and protect the gains of our hard-won independence, which include we fought so that practices that were rampant during the apartheid era, and the most important one, it's not important because it was good, the worst one was arbitrary arrests.